4, 3, 2, 1, 0.
Good morning. On behalf of Guru Sri Shanti Vijay Jain College for Women, I feel immensely honored to welcome you all to today's live virtual workshop on intellectual property rights and patents and design filling in association with Rajiv Gandhi National Institute of Intellectual Property Management, RGNIIPM. My special welcome to our today's guest of honor and speaker, Dr. Bharat N. Suryavanshi, sir, Assistant Controller of Patents and Design, RGNIIPM, Nagpur. Welcome, sir. A day without a prayer is a day without hope, and a life without prayer is a life without power. Kindly get ready for the prayer. I request Dr. Umarani PM Ma'am, IPR Coordinator, to give the welcome address and introduce our today's guest of honor to the viewers and the audience. Please, ma'am.
A warm greetings to all. On behalf of our Guru Sri Shanti Vijay Jain College for Women, I, Dr. P.M. Umarani, extend a very sincere, warm welcome to all here for this workshop. And I want to express my sincere gratitude to our esteemed institution's Honorable Secretary, Sir, Dr. Gautam White, Madam Principal, Dr. Malati, for their initiative. They have supported us in not just in our development, but also in enhancing our creativity and knowledge. A very special welcome our chief guest, Dr. Bharat Suryavanshi sir. He truly set a benchmark for multi-hyphenated achievements. Dr. Bharat N. Suryavanshi sir, working for more than 18 years in central government office under the patent, Ministry of Commerce and Industry, and presently sir is working as assistant controller of patents and designs. He has published various national and international articles. He has delivered many lectures on IPR in various parts of the country. He was deputed for training at Tokyo, Japan on examination and IPR issues. He has given landmark decision by rejecting Pfizer patent application for arthritis drug, which was filed in India 2005. So her letter of credentials. Next, we'll look forward to the virtual presence of our guest of honor, Dr. Bharat N. Suryavanshi sir, to grace this workshop. Thank you.
Thank you, ma'am. I now request Dr. Bharat N. Suryavanshi, sir, to carry on the session further. Please, sir.
Good morning to all. I also welcome you all for the IPR session on behalf of Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. As every college is having IPR cell and they are knowing about the different kind of intellectual property, even though I'll throw some light on what is intellectual property, what are different kinds and how to file them by sharing my slides. Are you able to see my slides? Ma'am? Are you able to see my slides? Anyone,
Yes, sir.
please?
Yes, sir. The slides are visible.
Okay. First of all, I introduce my office where I am working. I work under the Office of Control General of Patents, Designs, Trademark, and Geographical Indication. As you might have knowing, we are having different offices at different locations like Kolkata, New Delhi, Mumbai, and Chennai. PAS means Patent Information System. Now it is renamed as Rajiv Gandhi National Institute of Intellectual Property Management located at Nagpur. It is the only one training center in India. We are having trademark offices in addition to four. One is at Ahmedabad, that is Mumbai, Kolkata, Delhi, Chennai, and one is at Ahmedabad. Geographical indication office at Chennai. These are the pictorial view of our offices. This is our training center, wherein we are giving trainings to all the students of all the faculties, lawyers, company owners, managers, scientists, everyone, even the foreigners also who want to know about the intellectual property rights. This is our website. If you want to know detail, you can log on and see all about the patent, design, trademark, and share. This is an awareness program. I cannot go in detail with each intellectual property. If you want to be perfect or you want to know more, please log on to our website as well as social media account like Facebook and Twitter so that you will come to know about the different programs. Hello. Lectures. लगेच लेक्चर अजून एक आहे म्हणजे हॉलमध्ये त्याच्यानंतर करूया. So we are conducting many more programs. So please log on this and take the benefit of that. Let us see today's topic. What is intellectual property? You can see I've made a simple slide which can show you something blooming in the mind. It means I want to convey that the product of mind is called intellectual property. For example, day to day, we know petrol diesel rates are getting higher. Somebody among us or anyone in the world is thinking to give biodiesel. It's a renewable source which we can produce. So that idea itself, if it come in the form of process of production of biodiesel, or biodiesel as such is an intellectual property. Or somebody among us knows what is the design of Dell computer. If you are producing or manufacturing new design for any computer, that's an design intellectual property. If you're writing new novel story, that's an intellectual property in the form of copyright. So anything or the product of mind is called intellectual property. I'll quote another example. In December 2019, we heard about the coronavirus. At that time, we are not having any vaccine for that, but scientists throughout the world started to carry out the research. In the middle of 2020, we got Covaxin, Covishield, Sputnik. What is this? It's an intellectual property arises from the human mind because he thought on that and he given solution to that technical problem. So any kind of property that arises from human intellect is called as an intellectual property. Simply, I can say the product of mind. How that property arises? If you are in the classroom discussing with your professors or among the students or in group or alone, sitting and thinking on some problems. So the solution which arises during the discussion is an intellectual property. So we can define intellectual property as a property that arises from human intellect. It's a product of human creation. Let us see what is the background of intellectual property. Property means our mind directly goes to the tangible form of property. We say, I'm having car, gold, plot, flat, so I'm rich enough. But there is another kind of intellectual property called as industrial property or copyright, wherein industrial property includes patents, designs, trademark, and geographical indications. Let us see what is the definition of intellectual property, how we can define that. Intangible creations of whom? Human intellect. It's product home and having asset like any other form of property. If you're having gold, plot, flat, you say, I can sell it, get the money out of that. Same way, if you are developing biodiesel, you can sell it to Reliance company, HP company, and can get the money out of that. Therefore, it's an asset like any other form of property. For example, somebody is developing herbal medicine for cancer. So any company who is involved in the manufacture of herbal medicine can come to you. They can take license from you and they'll give the money for that. Therefore, it's an asset like any other form of property. Don't think that if you're having land, this, that, you are very rich. Even intellectual property is more beneficial. It's an asset like any other form of property. There are different intellectual property rights. IP is called as an exclusive right. If you are having patent on your name, you can exercise the power of that, nor your brother, sister, nor teacher. Only you can. Therefore, it also called as a negative right. And IP is an territorial right. Means you are filing that patents in India, it's valid only in the country of India. If you also establish this patent in other countries like USA, Japan, Germany, or China, or any other country, you can file in those countries by means of PCT or conventional application. Again, it's an licensable right. It means if you're developing vaccine, you can license to any company. Bharat Biotech of Hyderabad is developing some vaccination, then they can assign the right to Biocon of Bangalore also. By licensing means they have agreement and they can get the money out of that. What is patent? How we can define? Exclusive, monopoly privilege are right granted by the government to the community for 20 years from where data filing or priority for what? Commercial gain in consideration of the full disclosure of its invention as a territorial right, not worldwide. Means whatever you are doing invention, you have to write a detail in detail, then you are getting the right. For example, you are a computer science fellow. You are developing digital mosquito catching device. We know there are many devices in the market to catch the mosquitoes, but you are being a computer fellow, you are doing digital. How it will be? If I am bringing my hand towards that device, it never gives the shock because it recognizes it's an human hand. If mosquito passes, it gives the shock. This is digital. Means you are trying to give improvement in the technology. Means already many technology are there, you are doing new technology. Again, somebody is from chemistry. They are giving new medicine for psoriasis or new medicine in the field of fever. So that's again, you can apply for the patent. That's an invention. 20 years you can have the right of that. What is invention? Invention means new product or process. Any BSc fellow, BE fellow, MSc fellow has to do the project. That project, if you're doing process of production of something, it's a process. Product like ATM machine, it's a product. Herbal composition of shampoo is a product. Detergent is a product. Device is a project. Fermenter is a product. So what you are doing, that should be new product or portion. Process, it should be useful to all or anyone. Again, novel, it should be new, not same as in the public. Non-obvious and not public knowledge before the filing date. Then you can say your technology, what you develop, the project, what you develop is an invention, you can file the patent. Even for the paper publication, what we do, we check whether my article, the paper what I have written is in the public domain, is in the international journal or national journal or in other book. If not, then only we are going for the publications. Simple example I have taken is sharpener. Earlier, people used to use the blade to sharpen the pencil, but C.A. Busher has invented, we can say invented. You may be scientist, you might have written many papers, but you are not an inventor until and unless patent is awarded on your name. So C.A. Busher invented this, and it's not a sharpener. A tool in the engineering side, tool means something big machine. Hello? कशाची मीटिंग आहे आपली? मीटिंग कसली आहे आपली? हो 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 हो. So this is an invention. Again, in the general knowledge, we have studied who has invented electric bulb, who has invented aeroplane, who has invented many vaccines. We know all because we have studied in the school level only. So first time whoever invents, they will be awarded as an inventor. That is Thomas Alva Edison for the bulb, A.G. Bell for the telephone. Now many are here from computer science, science background, or another stream. Anyone can tell me, as though we are connected virtually, we can make this session as an interactive. Can anyone tell me this telephone was already in the public domain in the year 1876, even though scientists of that field tried to use the mobile phones? Why they thought of, what was the necessary to bring the mobile phone in the market? Anyone please? Why somebody's thought? Until unless we think innovatively, something new, we cannot do some new inventions. Our ancestors thought we got electric bulb. Somebody thought we got aeroplane. Somebody thought we got the mobile. What was the necessary to bring the mobile in the market? Dear professor, student, anyone can tell me. It should not be one way. Anyone? Because this telephone is having some disadvantage. One, I cannot change this telephone from my cabin to my principal's cabin because it is connected at a particular point where I have to come and speak. Again, 10 times I have dialed to connect my friend or my parents. It's very hectic, time consuming. To overcome that, scientists of electronic and telecommunication thought they came with the table phone. This table phone also, I cannot change from my cabin to principal's, but I can directly dial. One advantage, directly I can dial buttons 1, 2, 3, whatever may be. To overcome that, we got cordless phone, which were long, we can take in the hall, kitchen, drawing room. But we cannot take in the meeting, nor in the jib, nor in the car, nor in the train. To overcome that, our scientists thought they have given the mobile phone in India in the year 2000 or 2002. If you remember, simple Nokia of silver color was more than 5,000 rupees at that time. Now, any mobile is of 1,000, 2,000 up to 40,000. What is this? Improvement of technology from AG bell to mobile phone. When mobile came, only incoming was there, outgoing was there. Now video calling facility. Now you are sitting at your place, your college. I am at my institute. We are speaking to each other. What is this? Improvement of technology from AG bell to mobile. Why can't we think and do something new? I'll quote another example for the chemistry and other fellows. For example, we know paracetamol, very commonly used for the treatment of the fever. If you are having fever, after the breakfast at 8 a.m. you are consuming that, it takes 6 to 8 hours to reduce your fever. Somebody from chemical or pharma background comes with improved formulation of paracetamol. If that paracetamol reduces your fever within 2 hours, what is this? Improvement in the activity, therapeutic efficacy. Definitely that medicine can get the patent because 6 hours earlier paracetamol, now 2 hours. Again, it's an improvement in the technology of paracetamol. So any improvement you can get the patent for that if it's showing good results. Bluetooth. Earlier there is no Bluetooth. Now you are having Bluetooth in every mobile. You can transfer notes, data, anything, whatever you want. This is an invention done by Job Hudson. Nano car. There earlier Hyundai was there, Tata was there, Maruti Suzuki was there, but Nano car came in between with a lesser price. Vaccines, these are the example of inventions. Smart card, drones are the examples of invention. Let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, ornament, or composition of lines or color combination thereof applied to any article in the form of 2D, 3D, or both the forms. I'm having Skyland heater. This design is like this, but I am having simultaneously water jug. This design different. This is a Milton company, this Skyland. So both designs are different. You are having different combs in your home. Girls having different, boys having different. Even so, I am having two types of comb. New design. Even spectacle you can check. Nokia, Samsung, Reliance Mobile you can check. The design is different. I am using Dell computer to deliver the lecture. You might having Samsung or Apple or HP, any other computer. Printer design you can check. So anything which looks beautiful, that's an design. Flush design, brush design, mobile design, car design. If scientifically, if you see, even handle design is something new from Maruti Suzuki to Hyundai to some other company. Mere functional or technical feature of the article are not considered design. Term is 10 years. It can be renewed every 10 years subject to the uses. Means total 15 years terms. You can take the benefit out of that once you are registering the design. Even set of articles like cup sets, beautiful. You can register the design. Sofa set, chair set, spoon set. You can go for the design. Even you see in other foods, pharmaceutical. This ampoule design is different from this ampoules, this ampoules. This syringe is different from this capsule design is different. So anything which is different, if it is not in the public domain, you can go for the registration and you can sell to company or you can give license to them. You will get the money out of that. Therefore, it's an asset like any other form of property. In textile and jewelry, curtain designs, bed sheet, earrings, bangles, watches, all the designs. You can in you can see I'm using Timex watch. You might having Titan or any other company watch. The design is different. Even daily products, your office bag, your college bag may be different design. My wallet is different from this iron box is different from this iron box. I shown earlier two combs. This is a third comb design, Caesar design, sanitizing bottle design, aqua guide, aqua fine, thumbs up, Coca-Cola, all the design of the bottle. Carefully observe the design is different. Fridge, Whirlpool, LG fridge, you can check the design different. IFB washing machine, LG washing machine, the design is different. Even the pens, you can check the design different. Shape, configuration, surface of the bottle is also different. Even we know the sharpener, the dual in nature, different. Biscuits, we know Parle-G, Monaco, Bonbon, many biscuits like Britannia, Good Day, but the biscuit which attract to the children is Tom and Jerry facing. We know pencil, but the pencil with the peacock and parrot, the new design. This is an example of invention. How signal system came in the market are invented. Garrett A. Morgan, while passing on the road, he saw a terrible accident between horse carriage and the car. What we do if accident happen, we make them to reach the hospital or we give the water for them. But he thought, how can I prevent further accident? And he has given solution to a technical problem. Invention makes our lives safer. Why can't you and me think? During our many festivals in South India also, we prepare Naivedyam. We bring many flowers to our house to make the pujas. What we are doing? We are polluting the aquatic life by throwing in the pond, river and lakes during Ganpati and all. So once government came to know that this pond is polluted, this lake is polluted, they throw some chemicals. It is affecting the aquatic life of that. You are being a microbiology, biotechnology, or any science fellow. Why can't you think herbal method for treatment of pond or river water? It's a solution to a technical problem, but no one is thinking. Until unless we think innovatively, we can give the product. So listen, for example, if you're computer science, we know once our water tank is full, we get the alarm that your water tank is full. Why can't you develop a device which can give SMS alert to a farmer when wild elements are entering his field? That's again signal based. We are in 21st century. Why can't we do that? If you really think to do something, you can do. New designs you can check. Dress designs. Again, this is the design developed by one of the student of National Institute of Design, Ahmedabad. Why can't you think and develop new designs? Because we are not thinking. Therefore, we are not developing any design. How he got the idea to do? During his project in the final year, he went to the construction company site. He discussed with the many coolies. You are carrying stones, bricks, sand, cement on your head. Any problem? They explained. Since more than 5 years we are working in this field, we are having neurological disorders because nerves connection in the head. Back pain, disc pain. So he thought, how can I solve this problem? So he has brought this design. You can carefully check. It is not on the head. It is above the head. And most of the weight is shoulder with the sponges. So weight is distributed. It is directly not hitting on the head. So new design. You can come, anyone can, once you manufacture, anyone can take the design for that. Again, you can get the registration for the semiconductor integrated circuits layout design also, which you see in the software and all. Again, another kind of intellectual property called trademark or branding. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the good, to distinguish from the goods, like Reliance, Airtel, Biocon, Samsung, Nokia. What is this? These are the mark or brand value which they got the company. Good Day, Parle-G, all these are the different examples. It advertises goods and services, protect the innocent public from buying the goods of secondary quality. For example, we know Pounds powder, which everyone applies. Spelling is PONDS with the pink color bottle with the flowers. Somebody comes with POU. We never check what exactly mark is registered. What is the name of that? It will be cheating in the public. Puma shoes, Adidas shoes, you can check. In the roadside, you can get in 200, but in mall, more than 4,000 rupees. Because they are changing the spelling mark of that and they're coming in the second rate quality. So, we being highly educated, we should know what exactly the mark is registered. What is the Reliance Friends with how it will be? What is the brand of that? We should all understand. TM means trademark applied yet to get the permission. R with encircle is a registered trademark. You can see in many products these symbols are there. Term is 10 years. You can renew for every 10 year subject to the usage. There are different type of trademarks, collective marks, certification marks, taglines, slogans, and shapes. McDonald, Adidas, Dil Mange More. What is this? These are different kind of trademarks. Another kind of intellectual property called geographical indication. Place names used to identify source of origin, quality, reputation, or other kinds of products like Darjeeling tea, Kanchipuram silk sari. These are different kind of geographical indication. Term is 10 years. You can renew for every 10 years subject to the UCC. Makrana marble of Rajasthan, Ratlami Seva of Madhya Pradesh, Kanchipuram silk of Tamil Nadu. All these are different kind of. Even in agriculture products like Magai Pan, Devanelli Pamelu, Apimidi Mango, Kashmiri Saffron, Sahilicha Bihar, Coorg oranges. Another kind of intellectual property called copyrights. Copyright is a bundle of rights, provides holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term of protection is life of the author plus 60 years. It means you might have heard many singers sung the song. They are no more, but still they are getting the royalty for their songs. Many books, what you are referring now, may be written by some author. They are no more, but still they are getting the royalty for that. Even if you write books, stories, poems, novels, you can get then protection under the literary works under section 2. If you're doing artistic work under section 2C, you can get the registration. Dramatic works you can get, musical works you can get 2P, sound recordings, even cinematography films are getting protection in the copyright. Even software assets. If you're a computer fellow, you're developing in software assets. It's not a patentable, it's a copyright matter. But software with the combination of hardware like ATM machine, CT scan machine, or computer, these are comes under the patentable subject matter, but not software as such. This is an example wherein we can get protection for a single device with a different intellectual property. We know this is a symbol. What is that symbol? Anyone please? Apple sign is a trademark. LED display is a patent technology. User manual, how to use that laptop is a copyrighted matter. Layout of integrated circuit design is also there. So all the inventions are getting protected with the different. Therefore, Nokia will never copy the technology of Samsung. Samsung never copy the technology of Apple. They independently got protection to the technology as a patent. Design of the device as a design. Names as patent, Nokia, Samsung, Reliance as a trademark. These are different protection like this. Why your principal has kept this? Why your IPR coordinator has kept this program? What is the career opportunities in this? You can get the government job as an examiner of patent and design if you are MSc in chemistry, biotechnology, microbiology, physics, or any branch of BE. There are two papers. One is objective and the descriptive. If you're a law background, you can become examiner of trademark and geography indication or examiner of copyright also. You can become patent agent if you're a science graduate, any BSc science graduate. There are two papers. One is objective and the descriptive, then YOC. You can become trademark agent or copyright agent. You can have a GRF, SRF in patent facilitation centers, patent litigation and other opportunities you are having in private sector. You can work in the IPRSL, IPR policy of central government, state government, NGOs, or even in the IPR firms in different big cities we are having. You can work with them. Even you can also become inventor. I told that you are scientist, but you are not an inventor. By simple approach, identify some problems in and around you, solve that problem, definitely you can get the patent for that. For example, we know there are many shampoos, especially ladies knows. Vatika is there, Doe is there, Clinic Plus is there, many shampoos are there. Are they curing your dandruff within a week or a month? Many heroines are giving advertisement. Prove yourself. If not, then if you are being biotechnology, microbiology, or pharma, developing herbal dandruff curing composition, it's a new technology. You can get patent for that, and you can sell in the market. You can assign to any company. It's one. Or you are developing a device which convert solar energy into electrical energy. Again, invention. Method of production of biodiesel, method of production of biogas, Many inventions are there. A process of making dosa with new style of recipes, something new than the others. So all you'll get patent on this. If it is new, having inventive stuff, then only you can get the patent for that. How it will be new? It should not be published in India or elsewhere, or it should not be claimed in any other application in India or elsewhere. If your invention is proves technically advancement or having economic significance or both, then you are overcoming the inventive step objection which raised by the office. And that makes invention not obvious to a person skill in the art. Method of making dosa is very obvious to us, but to get in patent, your technology should not be obvious to anyone. So this is an definition of inventive step you have to qualify, like surprise result, solution to a long-standing problem, or great technical progress you are supposed to do, then you can get the patent. Like vaccine, how we got within 1 year, that's a new invention. If you are want to write your patent application, if you are writing shampoo or any device, title should be there. Preamble of that, what is your objective should be there. For example, I am developing herbal composition for treatment of Parkinson's disease because there is allopathy method are there. I am developing Parkinson's disease. It is my title. Object, there are many side effects for the allopathy, so I am giving the herbal. This is my object. Drawback, what was the earlier medicine, how it was, what efforts you are putting, solutions, drawings, if any. If you are carrying out DNA, something sequence listing, then sequence should be given. If plant material, which plant, from where you have to explain. Then examples, finally, you have to. This is like our PhD or thesis or project or what you write. Same, it is the content of our patent application. There are different claims. First claim is called independent claim, which define all the essential feature of the claim. Second claim is dependent. For example, process of preparation of herbal tea comprising steps of whatever step, taking cup of water, boiling, adding pinch of sugar, tea powder, then as per the taste, cardamom or ginger or some roots of medicinal plants. Again, his process as claimed wherein it is boiled at so and so temperature. Process as claimed wherein all the essential feature, then dependent feature you have to claim here. Now you learned what is different kind of intellectual property. Now how to file the patent application. Anyone can file the patent application. There is no age bar limit. Individual, natural, company, anyone can file the patent application. There is no age bar limit. How we can file? Directly you can go to the office of Chennai, you can file, or you are sitting in your office, you can file online because you are given the facility of filing online in July 2007. There are different jurisdictions as from south, your jurisdiction Chennai, state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu covers under these things. What are the minimum documents required to file the patent application? First, covering letter indicating the list of documents. Form 1, wherein applicants all the details, contact details, type of application, proof of right, you have to sign in that. Provisional or complete application has to be given. Form 2 is required for stating whether you are filing provisional or complete application. What is provisional? Once you get the idea in mind, you are filing, that is called provisional. Complete means after completing your research with the prototype ready, with the claims, if you are filing, that is called complete application. Form 3 is required whether same invention you are filing in the foreign country, then you have to mention which country you are filed, what is the status of that application. Form 5 is required for declaration of inventorship, means how you are adding in paper publication your friend's name, you can add your friend's name in the Form 5. Request for examination is Form 18. Until unless you request for the examination, we never examine. If you are filing physically, pay the fees physically, or online, if you pay the fees online. Fees is online filing 1,600 for a natural person, 8,000 for the others. All the details up to 30 pages only. More than that, per page, and more than 10 claims per claim, we are having the fees. Please see our schedule on the website carefully whenever you are filing the patent application. If you are filing offline, 10% in addition to that. For request for exemption, 4,000 for natural person, 20,000 for the company or others. If you want early publication, then separate fees for that. Anyone can request for expedite examination as per Rule 24B. Who can request? And what is the form required? Form 18A. Within 1 year, you can get the patent for that. If you are choosing PCT, means Patent Cooperability, in that India has an international searching authority, or IPA means International Preliminary Examination Authority, which can give report whether your technology is new or not. Or applicant is a startup, or as per 2019 rule, one of the applicant in your group is ladies or government organization or institute can also request for that. Then fees is 8,000 for individual, 60,000 for the others. These are some timelines. See, if you want to know about the patents, please go on www.ipindia.gov.in. Here, all the related, if you put the cursor, all the patent information comes. Put here designs, trademarks, GI, and training material will be RG and IPM. If you want to search whether your technology or your project, if you want to public search, you have to carry out. Now, how we are granting the patents in India? Once you are filing the patent applications, go for digitization, screening, and classify depending on subject like mechanical, electrical, botany, biotechnology, microbiology. We classify using international patent classification. We go for the publication. If you are requesting early publication, if you are paying the fees, otherwise 18-month publication. Once it published, anyone can oppose. That is called pre-grant opposition. If you are requested for examination within 48 months, we take it for the allotment to the examiner and controller. They examine case and they put the report that is called first examination report. You have to reply within 6 months. If you are not replying, you can take the extension of 3 months by paying the extra fee, that is Form 4. Within 9 months, by hook or crook, you have to reply for the letter. If you are replying, reply is okay, you will get the patent certificate. If reply is not okay, you will get the ACR, second exam report or hearing letter. If reply is not okay, it may, if you are not filed reply, that will be abandoned. Once it's granted, it's go for the post-grant publication. Within 1 year, only interested person can oppose. Starting, anyone can oppose, but here, after the grant, only interested person can oppose. Now, who is the person interested? For example, Maruti Suzuki company is developing some now engine, then Hyundai company, Tata Motors can oppose because they are involved in the same business. They are called as person interested. Once opposition filed, the grounds are opponent forward to the applicant with detailed reply on that, each ground. Simultaneously, we constitute opposition board inside the office. They give the recommendation on the opposition board. The ground which issued from the opponent will forward to the applicant. They give detailed replies. The replies for the opponent. Again, they give reply. If applicant or opponent request for the hearing, that is called post-grant hearing. We conduct the date. We fix the hearing date. We call both the parties, opponent, applicant. We discuss the case with them as like a court hearing across the table. If applicant is able to overcome all the grounds upon, definitely it will be granted. If applicant fails to overcome all the ground, it will be rejected. If you're granting or rejecting, we give the speaking order so that you can appeal in the higher courts. Now, if you are developing new design, how we can file? Anyone can file. Natural person fees is 1,000 rupees, small entity 1,000, startup 1,000. Other than that, company is 4,000. Form 1, full name, legal status, article, which prior data, signature, to set up the application you have to prepare. Power of attorney if you are going through lawyer or agent. Prior document required if you are having. Assignment if any. Form 24 if you are saying startup or MSP, you have to file with that. We classify your design. There are 32 classes, 230 subclasses that we are following. Locarno classification, you can check in the Google, you are having. Which section you are going. For example, you are developing design for foodstuff, class 1. If you are developing design for games, class 22, arms and all, class 21, games. If you are developing lighting apparatus, class 1, which class you have to mention in the application. Then you have to produce a sheet. We have to write detail about your designs, 1 or 2 pages. This developers, this is name of the college, women's college so and so. Total number of seat, 8 views, 9 views, how many drawings you are giving, you have to put total number of seat number 1 of 9, 2 of 9, you have to prepare. Now it recites in the shape and condition of the teapot as an illustrate, means how it looks, my teapot is beautiful, so it's a new design. You have to write signature of the applicant if your college is filing. If agent or applicant lawyer is filing, keep their name and let them sign. These are the bad quality of the design. You cannot cover such kind of designs. Now, what is the role of patent system? Encouragement or improvement of technology. We got X-ray, now we are having CT scan machine. Earlier, ageable telephone, now we are having different kind of mobiles. What is this? Improvement in the technology. Providing reward as an exclusive right for disclosure. Means if you are doing something new, government is giving reward, that is in patent, you can earn money out of that. Making profit or earning royalty through putting them in practice. If you are doing the patents, don't keep as a file record to get in promotion as a professor or principal. Please let it work in the public, get the benefit of it. Like Samsung and Sony TV, both are in the public domain, both are earning their benefit because some want Sony, they will take the Sony. Somebody wants Samsung, they take by the Samsung TVs. Transferring into public property after expiry of term or once pendition. Once if you're 20 years completing, then it will be in the public domain. Or you're getting the patent but unable to pay the fees for that, it will be seized, then anyone can use your patent application. What to do now? You came to know about the different intellectual property rights. Now, share the benefit of patent system, utilize the resource through organized R&D activities, capture the global market judicially, earn the profit through productive market. Don't come directly for doing something new. If Apple laptop, somebody comes, they directly not came in the market, they protect their technology as a patent, how it looks as a design, instruction how to use and cooperate, then came in the market so that other company never copy the technology of that. If somebody comes new shampoos, then they have to composition of shampoo as a patent, process of making shampoo is a patent, the design of that bottle is a design, then how to use, that's again instruction. So every technology is getting protection. Please protect and then come in the market. Then no one will be the competitor in the market. Thank you. Any questions? Now session is open for the discussion. Dear participants, you are most welcome to ask any type of question. It may be simple or complex. Dear coordinator, you are supposed to send or share the link in the chat box so that they will fill and they get the certificates.
So shall we move towards the end of the
Any
session?
question?
Uh,
Yes, question. Any questions?
no, sir, there are no queries.
No. It means you have understood or not, it's in my mind nowadays. I have taken very simple example. If your computer, I have taken the computer. If shampoos, I have taken very simple example. But I don't know, you are not asking any type of question. So hope any question further, my number is the coordinator. You can talk to them and message me. I'll answer the questions also. Okay. Thank you. You can proceed further.
Thank you. So there's a question.
Yes, please say the link. Yeah.
Revati
Please, anyone
Rao has asked, is patent valid in every country?
if you are filing in India, it's valid only in the India. If you want to establish your right in other countries, I told you USA, Japan, Germany, you are supposed to file your patent application in those countries also. Then only it is valid in that country, not in all countries. Wherever you are filing, you are getting the protection for that.
Thank you,
Any
sir.
other question?
There's one more question. Sir, is there any course regarding IPR which is provided by NIIPM?
Yes, you can do physical. You can come to our office. We are giving the trainings. Now, 16 January is a starting date for the student. We are having 50% concession. It's government fees. You can come and have the training in our institute also. And we are planning to give certificate courses also future. We already applied yet to get the permission from the government of India. But at present, we are having classroom trainings to get a patent agent or to qualify a work as a patent agent. Any other question?
Sir, Satvik S has asked to explain about the challenges of IPR.
There are a lot of challenges. For example, you're developing something new. How you're protecting that? How you protect your house by keeping the boundary of that, keeping guard in front of the house. But if you're developing new technology, how can you protect? First, get the patent and keep in watch. Anybody is using your patent in other country, other state. For example, you're from Chennai. You have invented new shampoo. Is that shampoo already got patent? But any other companies manufacturing, selling in the Karnataka or Maharashtra or any other part? it's your duty that you have to check. If somebody is found, you can go to the court, you can have an infringement of the patent and go for the criminal proceedings out of the patent office and court proceedings. There are a lot of challenges. Any other?
Yes, sir. Sir, please brief about patents for literary work.
Literary works never come under the patent, it comes under the copyright. Any work writing about autobiography, copyrights, or you are writing books, novel stories, anything that comes under the copyright, not under the patent. Patent is only for the technology, its product or process.
Thank you, sir. Thank you for the informative session, sir. Now we move towards the end of the session. On behalf of our college, Guru Sri Shanti Vijay Jain College for Women, I take this privilege to deliver the vote of thanks. Firstly, I thank the Almighty for showering His blessings to make this event a successful one. I thank our Honorable Secretary and Correspondent Sir, Dr. Gautam P. Ved, for his motivation and guidance. I thank our respected Principal Ma'am, Dr. M.K. Malati, for her immense support and encouragement. Thank you, sir. Thank you, ma'am. I thank our guest of honor, Dr. Bharat N. Suryavanshi, sir, for making this event a meaningful one and for having such an informative session. Thank you, sir. I thank Dr. P.M. Umarani, ma'am, IPR coordinator, for organizing and coordinating such an informative session. Thank you, ma'am. I thank all the audience and the viewers throughout the country who have joined us today. Eventually, I thank once again everyone. Thank you. Kindly raise for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जय जय मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे